Good evening, ladies and gentlemen, and welcome to It's Your Time Now. Thank you for joining us. Ladies and gentlemen, time and time again, we hear about government's commitment to accountability and to transparency and to the people of Trinidad and Tobago. But what does that mean? Put in simple terms, government accountability means that public officials, elected and unelected, have an obligation to explain their decisions and actions to the citizens. Government accountability is achieved through the use of a variety of mechanisms, namely political, legal, and administrative, all designed to prevent corruption and ensure that public officials remain answerable and accessible to the people they serve. Because in the absence of such mechanisms, it is inevitable that corruption will thrive. So does our current constitution in its current form assist in mandating public officials, both elected and unelected, to explain their decisions and actions to the citizens? And if so, how? And if it doesn't, do the proposed amendments to the Constitution do anything to rectify this most important omission? Well, according to the Prime Minister, who piloted the Constitutional Amendment Bill 2014, and I quote, with the power that the Constitution now gives you, you will have the power to demand even more accountability, transparency, and open governance. Close quote. That being said, today we will be examining in greater detail that statement in light of the current debate surrounding the President of the Republic, the Salaries Review Commission, and the Chief Personnel Officer, without of course, passing judgment or any aspersion on any office and/or person, as we are yet to hear from the President himself. Ladies and gentlemen, you would have heard many lawyers, politicians, political commentators, the Attorney General, the head of the public service, and the like, weighing in over the last week involving the request, approval, and acceptance of a $28,000 housing allowance for the President of the Republic at the same time he is receiving state housing paid for by taxpayers. Today, as we have done in the past, we intend to explore and discuss in a non-partisan way the constitutional issues that arise and, in particular, what powers the players involved have and do not have, and more so, what are, if any, the checks and balances on these powers. Starting with the Salaries Review Commission, Chapter 11 of the Constitution deals with the Salary Reviews Commission. In particular, Section 140 and 141 deals with its composition and functions. According to Section 140, subsection 1, there shall be a Salaries Review Commission which shall consist of a chairman and 4 other members, all of whom shall be appointed by the President after consultation with the Prime Minister and the Leader of the Opposition. Section 141, subsection 1 says, the Salaries Review Commission shall from time to time, with the approval of the President, review the salaries and other conditions of service of the President, members of Parliament, including ministers of government, and parliamentary secretaries, and other holders of such offices as that may be prescribed. It is a report from this commission, that is the Salaries Review Commission, that states there is an obligation on the state to provide the President with an official residence. However, where that official residence is not available for use by the President and suitable alternative accommodation is not provided, a housing allowance is to be paid. Secondly, we hear about the CPO, or the Chief Personnel Officer. This office, unlike that of the Salaries Review Commission, was not created by the Constitution, but by an Act of Parliament, namely the Civil Service Act. Part 3 of the Act deals with the Personnel Department and defines the Chief Personnel Officer, the CPO, as the head of the Personnel Department, whose duty, amongst other things, is to keep under review the remuneration payable to civil servants. It is the CPO, or Chief Personnel Officer, that approved the payment of the housing allowance to the President. And of course, the third player, thirdly, the President, which, like the Salaries Review Commission, is an office created by the Constitution, the supreme law, ladies and gentlemen of the land. That being said, the discussion before us today is, how should the Salaries Review Commission recommendation be interpreted? Whether the CPO had the authority to approve the housing allowance, and 3, if not, in the circumstances, what is the solution? To discuss this in further detail, it is my pleasure to introduce and welcome once again Mr. Vashist Maharaj to assist our viewers in understanding the legal framework and context in which this controversy relating to the President's housing allowance has arisen. Good evening, Mr. Maharaj. Lovely to have you again here with us. You're becoming a regular. Indeed, indeed. Thank you so much. I want to just, first of all, deal with the issue in simple terms. What we have before us is the payment of a tax-free monthly housing allowance of $28,000 to President Anthony Carmona. At the same time, he is receiving housing accommodation. Now, putting aside the morality issue for a moment, the question that I want us to examine and see if we can find an answer to is this issue, is this act unconstitutional and or illegal? So I thought what we could do, just you know, so that we're not all over the place, so we do it in a consistent manner. I wanted to begin with the Salaries Review Commission. That is a constitutional body. Now, their function is to review. It's a very, very, very clear word. Review the salaries and other conditions of service, in this case, of the President. They did a report, and their report says, where the official residence, which we do know is in Port of Spain around the Savannah, is not available for use by the President, and a suitable alternative accommodation is not provided, a housing allowance is to be paid. For our viewers, how do you interpret that section of the report by the Salaries Review Commission?
Well, it's two-pronged. It's either you're going to provide the President with house, or you're going to provide him with the means by which he can acquire a house. So they're mutually exclusive. You give the President a residence, you provide him with a residence, or you provide him with the means by which he can secure a residence. That's how I understand the term of the review report. And
I wanted to begin by asking you that question, because the word that we see, everybody's interpreting the statement, the words of the report in a different way. What is very interesting is that in particular, they say, where the official residence is not available for use by the President and a suitable alternative accommodation is not provided. Who therefore determines whether the accommodation is suitable or not?
There are two ways of construing that.
Yes.
It's either a subjective test or an objective test. Is it a subjective test in that the President must then say whether the alternative accommodation is suitable for him or not? And if it is a subjective test, then the decision is made by the President. If it is an objective test, It has to be made by a legal functionary, namely the Salary Reviews Commission.
Okay.
Right? My view is it is it's a subjective test. It is the president who will say whether the alternative residence that he's being supplied with is adequate or inadequate. In this case, the president has emphatically said that the alternative is adequate.
And of course, even if, for those of us who are questioning whether the president himself said it, whether it was suitable, we have to look at the fact of his actions. For example, when they were looking for suitable accommodation, the president himself had for stability for his children, as any parent would say, he preferred, having lived at Flagstaff before in his capacity as a judge, he wanted to continue doing so, and therefore arrangements were made, I believe, for 4 units at Flagstaff to be assigned to the president. And therefore, we can say that the president himself thought it suitable. But let us say, for argument's sake, because he is receiving the allowance and we're interpreting it as it's either or. It's either you have the accommodation, or if you don't, you get the means to provide the accommodation, which is what you had said. Let us therefore say for a moment it is unsuitable. What happened next, Mr. Maharaj, was the chief personal officer, and we have described...
Before you go on.
Sure. Please.
What is the evidence or basis upon which you say that, or you point to anything emanating from the president or his office to suggest that the accommodation is not adequate?
Well, you see, our program will go no further if we simply say
my point.
I understand what you're saying. Absolutely.
And I take your point. Let's look at it from all
you have to
objective
be fair
angles.
And objective, yes.
But I'm trying to point out to you how artificial it is when the office holder himself has never questioned. He has acquiesced in the whole process. He has stayed there. The suitability of the accommodation only became relevant when they were putting it forward as an answer to why he was living in the state and collecting the $28,000. Be that as it may, I wanted to make that point.
I agree with you.
There is no evidence to support what is being advocated, but we'll assume it is correct.
I understand that, but like I have said, he is, for argument's sake, and a lot of people had said, including, as we will see, the CPO, that the accommodation was in fact unsuitable. Let us deal and take what people have said so that we can look at it from both sides of the coin. The chief personal officer is the person who approved the payment of the housing allowance. Okay? Bear with me.
Sure.
She says, and I quote, "As a principle, where an office holder is provided with accommodation by the state, a housing allowance is not payable for any period during which he or she is provided with such accommodation. However, given the particular circumstances of the president, the housing allowance should be paid," and I close quote. So dealing first, the CPO, the chief personal officer, approved the payment, saying the particular circumstances of the president merited that it was not, the accommodation provided at Flagstaff was not suitable. Let us continue briefly. I think the issue, and where I would like our discussion to go, is not whether or not, because I have a feeling you want to comment before I go further, I will let you do so.
I am amazed. I am amazed as the gymnastics attempted by an office holder, which we shall look at her responsibility, totally out of her jurisdiction and performing all sorts of acts of gymnastics to justify what, in my view, is illegal and unconstitutional.
If we are going to therefore look at it, which is what I want to really do, to see is the act illegal and or unconstitutional, I think the issue is whether or not, let us say, she was right or wrong to give it. So let us perhaps move past the issue of suitability for a second, if you would allow us.
Sure.
The CPO, but let us look to whether she actually, in fact, had the power to decide. Point taken. Instead of we go down whether she should or shouldn't, or suitability, let's look at whether she...
objectivity.
We need to do that. Okay,
I take your point.
Right. So whether she had the power to do so. Now, in my introduction, you will recall, and ladies and gentlemen, I said that the CPO position is created by the Civil Service Act. That is an act of Parliament. It is not created by the Constitution, which by now you know is the supreme law of the land. Now, this Civil Service Act, ladies and gentlemen, you must know, relates exclusively to the public service. That being said, Mr. Maharaj, my question to you is, if the CPO, the Chief Personal Officer, was the person who had approved the payment for the President's housing allowance, and her jurisdiction only goes insofar as is limited to the public service, is the President a public officer?
Well, the answer to that
is a civil servant.
It's clearly and emphatically no. I don't think a first-year law student in LLB would advance any such a preposterous statement that the President of the Republic of Trinidad and Tobago, who has control, who is Commander-in-Chief, is head of state, Commander-in-Chief, is a civil servant. There's another point that I want to bear in mind when we come to interpret the jurisdiction of the civil servant and the chief CPO. When we look at 141.1 and we look at the jurisdiction of the Salary Reviews Commission, we will realize they are mutually exclusive. The Salary Review Commission is given jurisdiction over those constitutional offices that the Chief Personnel Officer does not have jurisdiction over.
She does not. And the law says that. That's not our opinion.
The office holders that she's given, the Salary Reviews Commission is given jurisdiction over, is spelled out. The President, Ministers of Government, Parliamentary Secretaries, that is not permanent secretaries, parliamentary secretaries, and holders of such other offices as may be prescribed. The point being, the reason that provision is put in is because the CPO and the Civil Service Act does not cover ministers of government, parliamentary secretaries, as well as the President.
Absolutely. And the Constitution, ladies and gentlemen, spells that out. We're getting into the...
Could I just point out one thing again?
I would love you to, but we must briefly go to...
also says it is the supreme law.
Absolutely. Ladies and gentlemen, as we get into the meat of this discussion of whether the act was... whether the CPO, in fact, had the power to give the allowance to the President, the housing allowance. As we get into the crux of the matter, we will take a short break and be back in a couple of minutes, and Ms. Maharaj will be here to shed some light on his views. Thank you very much. See you.